Okay. We continue with Republic Act 9262 or the Anti-Violence Against Women and Their Children Act of 2004. Dito tayo sa Section 9. Who may file petition for protection orders? Familiar naman siguro kayo sa term na petition, as in, it's some type of request. So, sino ang pwedeng mag-request na magkaroon ng isang protection order? So, it may be, well, primarily, the offended party, kung sino yung victim. Pwede rin na yung magulang or yung guardian ng offended party. Kasi nga, it's applicable, the law is applicable to women and their children. So, kung bata ang naabuso, then yung magulang niya ang pwedeng mag-file. Okay. Then ascendants, pag sinabing ascendants, these are direktang direktang lahi mo siya. Kumbaga, kung kayo ang direct ascendant ninyo is your parents, then ascendant nyo rin ang lolo at lola ninyo. Okay. Kapag sinabi namang descendants, it's either anak nyo, apo nyo. Yun yung descendant. Okay. Or collateral relatives within the fourth civil degree of consanguinity or affinity. So when we say consanguinity, these are your relatives by blood. Kumbaga, ito yung mga taong wala kang choice. Hindi mo sila napili dahil nga kadugo mo sila or by affinity. Ito naman yung mga naging kamag-anak mo dahil sa pag-aasawa. For example, nag-asawa na kayo. Yung mother-in-law nyo, father-in-law, sister-in-law, brother-in-law, cousins-in-law, pwede rin. Relatives by affinity mo sila. Okay, so, ang collateral relatives, buyoy, collateral relatives mo, napasok dito sa mga pwedeng mag-file ng petition for protection order ay yung hanggang 4th civil degree. Okay, officers or social workers of the DSWD or social workers of local government units. Basta social worker siya, DSWD or sa LGU ninyo, pwede siyang mag-file. Police officers. Police officers. Ba't ganyan yung pananalita ko? Police officers, pwede rin. Preferably, those in charge of women and children's desk. So, yung kada police station naman kasi may ano to? WCPD, Women and Children's Protection Desk. Yun. Sila yung mga preferred na mag-file ng petition. And then yung barangay captain ninyo, purong barangay or barangay kagawad. Pwede rin naman na lawyer, counselor, therapist, or healthcare provider of the petitioner. At least 2 concerned responsible citizens of the city or municipality where the violence against women and their children occurred and has personal knowledge of the offense committed. For example, kapitbahay ninyo. Yung mga chismosa ninyong mga kapitbahay, pwede silang pakinabangan. Kunyari, sobrang dami ng chismosa sa inyo, kaya alam nila yung nangyayari sa bahay ninyo, alam nilang may inaabuso. Yun. Yung mga chismosang yun, pwede silang mag-file ng petition for protection order. Okay. There. So applications for BPOs shall follow the rules on venue under Section 409 of the Local Government Code of 1991 and its implementing rules and regulation. An application for a TPO, temporary protection order, or permanent protection order may be filed in the Regional Trial Court, Metropolitan Trial Court, Municipal Trial Court, Municipal Circuit Trial Court with territorial jurisdiction over the place of residence of the petitioner, provided that if a family court exists in the place of residence of the petitioner, the application shall be filed automatically with that court. Okay. Paano naman? Paano ka mag-a-apply ng protection order? So the application for a protection order must be in writing, signed and verified under oath by the applicant, It may be filed as an independent action or as incidental relief in any civil or criminal case to subject matter or issues thereof partakes of it of a violence as described in this act. A standard protection order application form written in English shall be made available to facilitate applications for protection order. Nilalaman nito, names and addresses of the petitioner and respondent, yung relationship ng dalawang yon, statement of the circumstances of the abuse, description of the reliefs requested by petitioner, o ano yung mga gusto niyang matanggap niya, ano yung mga gusto niyang maibigay sa kanya. Um, Request for counsel and reasons for such. Kailangan niya ba ng abogado? Request for waiver of application fees until hearing and an attestation that there is no pending application for a protection order in another court. Sa isang korte ka lang pwedeng mag-file ng protection order. Hindi pwedeng, we call this forum shopping. In regular cases kasi, hindi ka pwedeng mag-file ng isang case sa madaming korte. Ang isang case, isang korte lang siya pwedeng i-file. I think you know this already. Siguro napasadahan nyo na to sa CJS ninyo. Pero yun nga yun. We call that forum shopping. Ganun din dito. You cannot file many protection orders in different courts. Okay? If the applicant is not the victim, kasi kanina 'di ba nabanggit natin yung iba't ibang mga tao na pwedeng mag-apply ng o mag-file ng protection order. Hindi lang naman yung biktima, madaming pwede. Kahit nga kapitbahay yung chismosa, pwede, 'di ba? Basta dalawa sila. The application must be accompanied by an affidavit of the applicant attesting to the circumstances of the abuse suffered by the victim, the circumstances of consent given by the victim for the filing of the application. When disclosure of the address of the victim will pose danger to her life, it shall be so stated in the application. Baka kasi nagtatago na yung biktima kasi nga feeling niya nanganganib na yung buhay niya. So, kailangan ilagay mo lang doon na yung pag-disclose, yung paglalagay ng kanyang address doon would endanger the person. So, lalagay mo lang. In such case, the applicant shall attest that the victim is residing in the municipality or city over which the court has territorial jurisdiction. So, ilalagay mo na lang yung municipality or city. Angeles City, Mabalacat. Medyo mahirap naman kung mag-house to house ka, di ba? Para lang hanapin yung taong yun. Basta ang requirement lang, may territorial jurisdiction yung court doon sa municipality or city kung nasaan yung victim. And shall provide a mailing address for purpose of service processing. Okay, an application for protection order filed with the court shall be considered an application for both a temporary and permanent protection order. Yung mga barangay officials ninyo o kaya yung court personnel ay pwedeng tulungan yung mga applicants para dun sa petition for protection order. Okay? Law enforcement agents shall also extend assistance in the application for protection orders in cases brought to their attention. Okay? Protection orders, PPOs and PPOs, shall be enforceable anywhere in the Philippines. And a violation thereof shall be punishable with a fine ranging from 5,000 pesos to 50,000 pesos and or imprisonment of 6 months. So regardless kung saan na-issue ang protection order, it's applicable anywhere in the Philippines. Okay? This is usual naman kapag ang isang petitioner ay walang kakayahan na kumuha ng sariling abogado, meron namang public attorney's office. Okay. Section 14, ito, mahalaga to. Barangay protection order, who may issue and how. So BPOs refer to the protection order issued by the punong barangay or barangay captain. Obvious na, syempre, di ba? Barangay protection, barangay captain. So, yun. Ordering the perpetrator to desist from committing acts under Section 5A and B of this Act. A punong barangay who receives application for a BPO shall issue the protection order to the applicant on the date of filing after ex parte determination of the basis of the application. If the punong barangay is unavailable to act on the application for a BPO, the application shall be acted upon by any available barangay kagawad because this is urgent. Hindi mahirap siyang ipagpabukas-bukas kung binubugbog na nga yung babae, binubugbog na yung bata. Papagpabukas mo pa ba, baka ikamatay na nila, di ba? Kaya pwede yan. If the BPO is issued by a barangay kagawad, the order must be accompanied by an attestation by the barangay kagawad that the punong barangay was unavailable at the time for the issuance of the BPO. So BPOs shall be effective for 15 days only. 2 weeks lang. Immediately after the issuance of an ex parte BPO, the punong barangay or barangay kagawad shall personally serve a copy of the same on the respondent or direct any barangay official to effect is personal service. The parties may be accompanied by a non-lawyer advocate in any proceeding before the punong barangay. So, pwede naman na hindi ka magsasama ng abogado doon kapag magfa-file kayo nito doon sa barangay. Okay, take note ha, 15 days lang. BPO shall be effective for 15 days. Okay, temporary protection orders, TPOs. This refers to the protection order issued by the court. Korte na ito. On the date of filing of the application after ex parte determination that such order should be issued. A court may grant in a TPO any, some, or all of the reliefs mentioned in this act and shall be effective for 30 days. Okay? TPOs are effective for 30 days. The court shall schedule a hearing on the issuance of a TPO prior to or on the date of the expiration of the TPO. The court shall order the immediate personal service of the TPO on the respondent by the court sheriff, who may obtain the assistance of law enforcement agents for the service. The TPO shall include notice of the date of the hearing on the merits of the issuance of a TPO. TPO naman, Permanent Protection Order. This refers to a protection order issued by the court then after notice and hearing. So dito, meron ng hearing. Okay. Respondent's non-appearance despite proper notice or his lack of a lawyer or the non-availability of his lawyer shall not be a ground for rescheduling or postponing the hearing on the merits of the issuance of a PPO. Kasi 'di ba, may mga pagkakataon na kapag hindi dumating yung abogado, walang abogado, napo-postpone ang hearing. But in issuing permanent protection orders, hindi yon magiging dahilan. It would not ano to? Have an effect. It would not have an effect on the merits of the issuance of a PPO. So if the respondent appears without counsel on the date of the hearing of the PPO, the court shall appoint a lawyer for the respondent and immediately proceed with the hearing. So kung sino na lang yung tingin ng korte na pwedeng mag-abogado para sa'yo, mag-a-appoint na siya. Hindi ipopostpone yung hearing dahil lang wala kang abogado. Ang tinutukoy dito yung yung respondent, hindi yung nagpetisyon, hindi yung petitioner. Okay? In any case, the respondent fails to appear despite proper notice, The court shall allow ex parte presentation of the evidence by the applicant and render judgment on the basis of the evidence presented. Kasi may pagkakataon din na yung mismong respondent ang hindi naman nagpunta. Tuloy pa rin yung pagpe-present ng evidence. So the court shall allow the introduction of any history of abusive conduct of a respondent, even if the same was not directed against the applicant or the person for whom the applicant is made. Kumbaga, basta nagpapakita ng history na abusive itong taong to, na may ganito siyang character, behavior. May ganun siyang behavior na abusive nga siya, kahit hindi directed doon sa petitioner, pwedeng i-present yon as evidence. The court shall, to the extent possible, conduct the hearing on the merits of the issuance of a PPO in 1 day only. Where the court is unable to conduct the hearing within 1 day and the TPO issued is due to expire, the court shall continuously extend or renew the TPO for a period of 30 days. So kapag hindi pa siya makapag-issue ng PPO, kapag sa tingin ng court na hindi sapat ang dahilan para mag-issue siya ng PPO at pa-expire na yung PPO, yung temporary, pwede niya namang i-extend yung temporary. So remember ha, ang PPO is only 30 days. Yung pinakauna natin pinag-usapan, yung BPO, yung sa barangay, 15 days lang yun. Pag permanent, di syempre, permanent na yun. Okay? So the extended or renewed TPO may be modified by the court as may be necessary or applicable to address the needs of the applicant. The court may grant any, some, or all the reliefs in a PPO. A PPO shall be effective until revoked by a court. So that is the only instance where a PPO will be void kapag sinabi ni court na i-revoke na niya. Revoked by a court upon application of the person in whose favor the order was issued. The court shall ensure immediate personal service of the PPO on the respondent. So the court shall not deny the issuance of protection order on the basis of the lapse of time between the act of violence and the filing of the application. Naari kasi na ngayon ka inabuso, ngayon nagawa yung violent act, then hindi naman sa lahat ng pagkakataon ay ngayon din pupunta na ang biktima sa barangay o sa pulis. Sabi ko nga sa inyo last meeting, 'di ba? Meron tayong battered woman syndrome. And etong it's a cycle kasi. Merong honeymoon phase na kunyari sinaktan ka, tapos maghihingi ng sorry, magdadala ng flowers, magdadala ng chocolates. Kumbaga, susuyuin ka. Tapos after some time, babalik na naman doon sa pambubugbog. Tapos manunuyo na naman. It's a cycle. So, somehow the person, the victim rather, ay hindi nakakapag-decide kaagad kung pupunta na siya doon sa authorities. Kaya, ang sinasabi dito, ang court, hindi siya magde-deny ng pag-i-issue ng isang protection order base lang sa tagal na na-commit yung violent act at doon sa pagpa-file ng application para magkaroon ng protection order. Kumbaga, walang connect yun. Okay. So regardless of the conviction or acquittal of the respondent, the court must determine whether or not the PPO shall become final. Even in a dismissal, a PPO shall be granted as long as there is no clear showing that the act from which the order might arise did not exist. Okay? Anong mangyayari kapag na-violate ang protection order? A complaint for a violation of a BP with any municipal trial court, metropolitan trial court, or municipal circuit trial court that has territorial jurisdiction over the barangay that issued the BPO. Violation of a BPO shall be punishable by imprisonment of 30 days without prejudice to any other criminal or civil action that the offended party may file for any acts committed. Judgment of violation of a BPO may be appealed according to the rules of court. During trial and upon judgment, the trial court may motu proprio issue a protection order. Kapag right then and there, pwede na mag-issue ng protection order as it deems necessary without need of an application. Violation of any provision of a TPO or PPO issued under this act shall constitute contempt of court, punishable under Rule 71 of the Rules of Court, without prejudice to any other civil or criminal action that the offended party may file for any of the acts committed. Okay. Bond to keep the peace, Section 23. Hindi siya gumagalaw.